So I am here on time.
Oh, Massey sir, good morning.
Good morning, sir.
Because the other
Because
name was coming, that
My
was
picture
confusing.
is there,
because
but
you are
my
connected.
I will
name is
change
not
the name,
coming
sir.
here.
हाँ,
My name is not coming here.
डॉक्टर साहब का नाम चेंज कराओ शोभिका.
Sir.
So good morning, everyone.
Good morning.
Thank you. Hello, Dr. Sam. With the permission of all of you, I think adherence to the time, we must start. So we start this particular occasion with greeting all of you. As we all know the importance of the occasion, we all know the genesis, that how this particular day came into being, what were the efforts made, processes followed, and the contribution made by very distinguished luminary professionals of that time. So we are celebrating today the Constitution Day. And this becomes more important for us because our university is named after that great man, Dr. Bhim Rao Ambedkar. So it's a befitting tribute to Dr. Bhim Rao Ambedkar, remembering him with gratitude, and for our academic fraternity, creating an occasion for academic discourse. In that context, today we have with us a very eminent, distinguished academician, Professor I.P Massey. We all know about his academic attainments, and it was really very great of him that when I had a talk with him just the day before, he was very graciously agreed to enlighten us, enlighten our students, our principals, and the academic fraternity on certain aspects of the Constitution or the importance of this occasion. So, while welcoming Professor I.P Massey Sahab, I welcome all of you on this occasion for becoming a part of this academic retreat. It's a retreat because the academician like Professor Massey, there are many people came across, and whenever I had a talk, and when there was a talk about administrative law, constitutional law, Professor Massey's name was referred with great honor and respect. And when I requested Professor Massey, it was really very kind. So Massey Sahab, I welcome you on behalf of the university. I welcome you on my own behalf, and you may kindly enlighten us in whatsoever manner you think proper, because you are the expert. Subject is vast, so you have to consolidate, you have to comprehend in a manner that the time is utilized fully. With this, I welcome you all once again and request Professor I.P Massey, sir, to kindly make his observations and enlighten us. Professor Massey, please.
Thank you, sir. Am I audible?
Very much.
Okay, sir. So, I am really grateful to you for this kind introduction which you have given. But I think that introduction does not define me or describe me. So therefore, if you want me to introduce myself to you, then I will say only one thing, that throughout my educational career spanning more than 50 years, I have never considered myself anything more than a mere student of law, because I have always felt that a person cannot claim to be a professor of law unless he is first the student of law. So I am happy, sir, that you have given me this opportunity to interact with the law faculty and with the students and principals of the university. This lecture event is a collaborative effort of Dr. Ambedkar Law University and National Law University, Jodhpur. I express my gratitude for organizing this lecture event and my participation in it to Professor Dev Sarup, the Honorable Vice Chancellor of the Dr. Ambedkar University, Jaipur. And I also express my gratitude to Dr. Professor Poonam Saxena, the Vice Chancellor of the National Law University, Jodhpur. On behalf of both the universities, I wish you all a happy Constitution Day. On this day, we also pay tribute to the members of the Constituent Assembly and especially to the chairman of the drafting committee, Dr. Ambedkar, which tirelessly worked for almost 3 years to give this Suprema Lex to us, this constitution to us. Perhaps you know that world over, the average time taken in writing the constitution is about 16 months. But our constitution framers took about 3 years to draft this constitution for us, which is a supreme law of the land. Why it happened? Why they took so much of the time? I think there were reasons for it. One was that India is a very vast country. And it will not be out of place to say that India is not a country, it is a continent. Second thing was that India has a phenomenal diversity. Lingual diversity, social diversity, cultural diversity, every type of diversity which you can imagine. And the third was that India was never governed by any central one agency in its whole history. And the fourth was that though we had a very supreme culture in India, which we call Vedic culture, which was highly democratic, inclusive, egalitarian. But because of various reasons, internal and external, this culture was on the decline in India. So to draft a constitution for such a society was certainly not an easy task. It was a Herculean task. And therefore, instead of 16 months, our Constituent Assembly took 3 years. On this occasion, I would like to pay tribute to the members of the drafting committee headed by Dr. Ambedkar, the members of the Constituent Assembly, which was presided over by Dr. Rajendra Prasad, who took so much pain and the time for drafting this constitution for us, which is our foundation and which is the basic constitution for us. On this day, we also pay tribute to those who made supreme sacrifices so that we may live with honor and dignity in an independent India. And on this day, we also pay our gratitude to the people of India who worked very patiently in order to see that the constitutional democracy succeeds. Perhaps you know that when the constitution was finalized by the Constituent Assembly on 26th November 1949, it came into operation on 26th January 1950. And since then, we were celebrating 26th November as a law day. But when on 11th October 2015, our Prime Minister, Narendra Modi ji, was inaugurating Dr. Ambedkar statue of Equality Memorial in Bombay, he declared that this day will be celebrated as a Constitution Day to highlight the contribution of Dr. Ambedkar in the drafting of this Constitution. So why we celebrate the Constitution Day? In my opinion, there are 3 reasons for it. Perhaps you know that every constitution has 2 parts, which we call hardware and software of the constitution. So on this day, we revisit the constitution to evaluate the role of our constitutional institutions, that how much they have performed and how much they have still to perform. On this day, we also express our faith in the lofty values of our constitution. which we call the software of the Constitution. So we visit the Constitution to evaluate our successes and our failures. In this limited time, it will not be possible for us to evaluate the functioning of all the three institutions of our governance: the parliament, the executive, and the judiciary. So therefore, I decided that I will confine myself to the role which the judiciary has played in interpreting the Constitution, which determines the longevity of any constitution. We know that the longevity of any constitution is determined by three factors. One factor is the sagacity of the people, with what wisdom and reasonableness and fairness people elect their representative who govern them. Sagacity of the people. Second is the morality, political morality of the ruling party in power, their honesty and sincerity in walking on the road that has been identified by the Constitution, their moral authority, their character. And the third is the creativity of the judiciary. And I have no hesitation in saying that no matter at times our judiciary has also faulted, but it soon corrected itself, and therefore the role of the judiciary has been responsible for the longevity and the strength and vitality of our Constitution. Perhaps you know that when the Constitution was being drafted, the judiciary had not been given any activist role. The judiciary had been given a very minor role, which becomes clear from the fact that when Article 21 was being drafted, right to life, then it was very much deliberated that what role we should give to the Supreme Court in protecting the life and liberty of the people. And it was decided, unfortunately, by the majority of our people in the Constituent Assembly, that we cannot give very wide role to the judiciary in the matter of protecting the life and the dignity of the individual. And therefore, deliberately, they did not include the concept of due process in Article 21, whereas included the concept of procedure established by law into the Constitution. However, through its own design, through its own effort, The activist role which the Supreme Court is now playing in protecting and developing the Constitution, it has been snatched by the Supreme Court, as we generally say it. It had not been given any activist role. It is snatched in a manner in which, in the American Constitution, Justice Marshall snatched it when he decided the pace-setting case, Marbury versus Madison, in 1803. We all know that American Constitution is based on a strict separation of power. And therefore, the Constitution has not given any power of judicial review to the Supreme Court. Otherwise, it would have violated the principle of the separation of power. All the three departments should be separate. Persons should be separate. Functions should be separate. And one department should not interfere into the functioning of another department. Therefore, the court was not given any power of judicial review. However, this is the most enigmatic part of the American constitutional history, that how the Supreme Court is now exercising the power of judicial review and is interfering into the functioning of the Congress and also the functioning of the president. And the answer is that it was snatched by the court itself. In this particular case, Justice Marshall, who was the Chief Justice at that point of time, said a classical sentence: judges are bound by the Constitution, but Constitution is what we judges say it is. We are bound by the Constitution, but the Constitution is what we judges say it is. And therefore, the court started exercising the power of judicial review. In the same manner, our Supreme Court slowly started expanding its power through the power of judicial review, which was given to it. And now it has reached at a point where it can exercise its power in an activist manner to protect the Constitution, to protect the rights of the people, to enforce rule of law and constitutionalism on the government. And for this reason, our Constitution has survived for such a long time, and we hope it will survive. So therefore, when we evaluate the role of the Supreme Court, I will not go into the details of other roles, but I will confine myself to the role of the Supreme Court so far as developing a fine strands of human rights jurisprudence in India. And I can identify the 7 strands of that particular human rights jurisprudence developed by the court, by which our rights which are given in the Constitution are alive and people are able to enjoy those particular rights. I will say that the first strand is the preservation and expansion of judicial review by developing the theory of basic features. The law students and professionals know it. By importing the doctrine of due process into Article 21, the Supreme Court has preserved and extended its power of judicial review, which is necessary for the people of this particular country so that we may live with honor and dignity. The second strength, which I can find out, is the anti-arbitrariness. Because arbitrariness in any governmental action or in any sphere is anti-democratic. And therefore, Supreme Court has taken care that in the administration and in the governance of the country, everything must be done according to law, and arbitrariness is to be avoided. For this reason, I have in mind the expansion of the concept of equality under Article 14, which now includes not only the unreasonable classification, but also the all arbitrary action of the government. So now people can go to the court, and if there is any action which is arbitrary, which is illegal, which is not fair, which is not reasonable, it can be challenged as violation of Article 14, the Equality Clause. And on this particular ground, the courts have started examining the President rule and exercise of administrative discretion. Perhaps you know that discretion is a very serious matter because it is considered to be a rule-free area where every person is free to take action according to his own subjective satisfaction. Then how it is to be controlled when there is no objective criteria? For this reason, the courts have developed very fine judicial manageable standards in order to control the exercise of administrative discretion. Discretion and the exercise of discretion is one single factor that can take a state to the direction of a failed state. And therefore, bringing the concept of non-arbitrariness and due process into the Constitution, the court has developed very many judicially manageable standards. The third is redefinition of human rights. Sorry. Redefinition of human rights. And this has been done by collapsing the compartmentalization of the human rights of the people into the civil and political rights, the economic and social rights, which are given under two different parts of the Constitution. Part third, which lays down fundamental rights, are enforceable. And in part fourth, which are only directive principles. The economic and social rights were not enforceable in a court of law. The Supreme Court has eliminated this divide. And not only they say that both the directive principle and the fundamental rights have a correlation, and there must be some kind of a homogeneity between them. And by this, they have eliminated the strict compartmentalization. And therefore, our whole concept of human right has been expanded. The fourth strand of the human rights jurisprudence developed by the Supreme Court may be the democratization of the judicial process. Problem was that no matter the courts were open for everybody, but vast majority of the people who were poor and deprived, they had no opportunity of any access to the constitutional court because of the money which was required. And therefore, the vast majority of the people of this country had no access to the courts. In order to do away with this, the court developed the concept of public interest litigation, where any person, public spirited person, can go to a court of law on behalf of those disadvantaged and deprived sections of the people who cannot reach and have access to that particular court. And so, in this particular manner, the court has democratized the judicial process. Then the fifth strand, to my mind, is the expansion of judicial capabilities. I told you that Constitution had not given any major role to the court so far as protection of the human rights were concerned. But slow and silently, through the judicial process, the judiciary has expanded judicial capabilities. And now, in case of violation of the human rights, the court can award compensation. Court can exercise contempt power, criminal or civil, if its order are not complied with and deliberately avoided. The court has started giving exemplary damages where the administrators do not seriously take the rights of the people, especially these disadvantaged sections of the community. The courts have started ordering their own investigations. This was never done, so that the truth may come before it. The court has also started appointing its own inquiry committees and commissions so that the justice may be done to the people. The court has started giving directions also, not only questioning, but giving directions how to exercise that power under Article 142 of the Constitution. The sixth is, and which is very important, the court has extended the life of the Constitution. and made it, if I will not use the word immortal, but its longevity has been increased for a considerable period of time. Because now, through its own judicial process, the court has started exercising power of judicial review, not only all the power under the Constitution, but also the constituent power of the government. Nowhere, perhaps, in the whole world, the Constitution, constituent power are not controlled by the state. How the Constitution is to be amended? What cannot be amended? Perhaps Indian Supreme Court is the only court in the world which has extended its power to the constituent power of the court. The Supreme Court has said, the famous Keshwanandan Bharati case, that Parliament has the power to amend the Constitution, but it cannot amend the basic features of the Constitution. And in this manner, the court has protected the Constitution from being a plaything in the hands of the transient majorities in the Parliament. And perhaps this is one single contribution of the court which determines the longevity of this Constitution. Seventh may be that it is the judiciary which, in order to protect the rights of the people and the Constitution values, has linked our Constitution to an outside source which cannot be controlled by any government. And by linking the Constitution to that outside source and making it a part of our Constitution, classical example of judicial activism. And so now our Constitution has been linked to natural law. And therefore, all natural rights have become the part of our Constitution. The court has introduced and brought in again the concept of due process. That also is an effort to link the Constitution to that outside world, which is beyond the reach of any person. And by this manner, the court has extended the life to an indefinite period, so far as Constitution is concerned. And eighth is that it has, through its various decisions, has started keeping a supervision and check on corruption, which is in India is eating into the vitals of the country. Discretion and the resultant corruption. In India, perhaps the two factors that can push any country towards the wall, and that country becomes a failed country. The Constitution, the court, through its active posture, has saved the country by entering into this particular era. And as I said, the court now actively gives relief in every case of misuse of political power or administrative power and the corruption into it. You can think of many other strands, but in my opinion, these are the most important strands of the approach of the court so far as the development of fine constitutional human right jurisprudence is concerned. In the end, I will say a famous saying that Constitution has not failed us. A very well drafted constitution. A constitution which took the best from any source and changed that material to suit the genius of the people of this particular country. Constitution has not failed us, but we have failed the Constitution. If the Constitution fails, the sagacity of the people will be the main reason, lack of sagacity of the people, that our Constitution would fail. Because we know that the road which has been crafted by the Constitution for us, that is constitutional democracy. That road is the only road on which we have to walk. And the enigma of this walking is that it is a constant walking without reaching. No country can say that today we have become completely a democratic country where the human rights of the people are regarded and safeguarded. So there is no destination on this particular road. The pleasure is in walking and not in reaching. And that attitude, unless we develop and help the court in exercise of its powers in an activist manner, the constitutional longevity cannot be safeguarded. I do not say that there are no limitations so far as our judiciary is concerned. There are, but limitations are few, but the benefits which the judiciary has brought to the people in this particular country and to the country. And if we are democratic today and moving in that particular road steadfastly, in my opinion, the credit goes much to our judicial system. Thank you very much.
Thank you very much, sir. Your statement that the pleasure is in walking, not in reaching. I think it defines the whole process. And of course, the way you have stated about the strands, the role played by judiciary, it's immense. Sir, if you kindly allow, would like to take only 2 questions, one from one student, one from one teacher.
Sir, I have
Answer.
Yes, Akanksha, please.
Thank you.
But
Thank you,
important
Prof.
thing is,
Sir,
before you ask any question,
sir,
I admit that in law there are no final answers. Law is only a heuristic science. Law is not a fixed science. It is a
Absolutely.
heuristic science. So please ask your question.
Right. Akansha, please.
Thank you, sir. Thank you so much for such a rich lecture on our constitution connected with the judiciary. My question is in the current scenario, we are seeing a upcoming debate over uniform civil code. Few political parties says that in our constitution there is a mention that uniform civil code is supposed to be implemented after certain years or certain time or certain achievements, but few other political parties claim or interpret it in a different manner. They say that uniform civil code has no mention in the constitution and it is not to be implemented, it is not to be imposed on the country. So in your opinion, whatever drafting committee headed by Dr. B.R. Ambedkar wanted about uniform civil code?
Sir, please.
The very relevant question and very current question. Question is diversity or uniformity? India is a very diverse society. Democracy appreciates diversity to a certain extent, and certain extent uniformity. So therefore, the concern of the drafter of the constitution was that can we bring a cohesion and some element of uniformity, because the basic task and the most difficult task of the people on the day of independence was how to make this mass, huge mass of the people into a nation. And we are still only a mass of people. We have not become a nation. And therefore, everybody was eager that there must be some kind of a uniformity. But unfortunately, in India, we have a constitution which allows it our religious freedom. And our laws by which we are governed so far as personal matters are concerned, for example, marriage, divorce, adoption, all other things, we believe that they have a source in the religion. And if a government cannot make a religion, they cannot make a religious law. So, of course, uniformity is the end. We have to reach that end someday. But for this, we have to be prepared. Because in a democratic system, you cannot impose anything against the people, against their will. And therefore, we have to wait. And that is why our constitution made this only a directive principles of the state policy. Because diversity is a rule of democracy, but uniformity is also necessary for the homogeneity of that particular society. Therefore, democracy demands that diversity should prevail unless the people themselves demand that we want uniformity. So therefore, we have to wait and we have to see. For example, I tell you that Christians demanded that we must have a elected law because our family law was highly diverse. We were governed by the British laws. And therefore, there was a demand that the laws must be unified and codified. And therefore, the Christian law has been, marriage law has been codified. Unless this kind of a awareness and demand grows from the people itself, I think it should not be our first priority. There are many other problems in this particular country, and therefore we must list a priority of those particular problems.
Thank you, sir. The way you have explained is very nice, sir. Thank you, sir. One question from one of our, yeah, thank you again. One of our principals, someone can have one question, please.
Okay, please.
Any principal, Mr. Abraham?
Sir, it's such a joy to hear you on as a face-to-face today. Just one question, sir. We have seen that whenever the executive was very strong, the judiciary was not very vocal. And whenever the executive was not so strong, the judiciary was very vocal. As an expert in constitution and administrative law, is there any way that we can balance this tension that exists?
True. Our history proves this particular fact, that whenever the executive was strong, the judiciary showed the signs of weakness. And when the government is not so strong, the judiciary acts in a bold manner. And the clear example of this is the behavior of the judiciary during emergency period, when the case was decided, habeas corpus case. The executive was very strong. There was an emergency in India. The rights have been suspended. The question was, can the fundamental right of the people be suspended by anybody? Because they are natural rights which belong to every person for no other reason except that he is a human person. So can you suspend those particular rights? And government was strong. Judiciary showed the sign of weakness, and they said, yes, if there is an emergency, which the Constitution says that fundamental rights can be curtailed, and therefore nobody can have access to the court for the enforcement of the fundamental right. I think when this decision was taken, the judges were not showing any sign of weakness, because one of the judges on that particular bench, I will not take the name, said later on that, why, sir, you gave this kind of a decision when you knew that it is inherently wrong? The judge said there was an emergency. Everybody was afraid. And therefore, as a human being, I was always under stress and afraid. But he said beautiful thing, that I was not worried and afraid for my own safety. I was worried about the safety of my institution, which I am serving. And when the government is strong, the danger is that even the institution may be harmed. So and that we have seen in Pakistan. When the government was strong, the constitution, the court had been abolished. And so it was that fear in the mind of our judiciary, and perhaps right fear, it is a matter of practicality. that you have to stay in power so that you can serve the country. But if that institution is taken away, neither you will be there and neither you will have the opportunity to serve the nation. And in my opinion, the approach of the court in that particular era when the government was the strongest, perhaps the most rational idea. And here now, we are also seeing the signs of conflict between the Supreme Court and the government on the basis that the Supreme Court has started questioning the appointment to the Election Commission. And therefore, in democracy, you have to walk a very tight rope because the purpose is to reach the end. If you cannot reach the end, you are not disabled to reach the end, then perhaps there is no fun in trying to show that particular strength. Unless the people are wise enough to understand the problem, because in a democracy, it's the people who decide everything.
Thank you, sir. Sir, I have also one observation. And this is that what is the remedy to put a check on this discretion and resultant corruption? How to deal with from the constitution point of view, from judiciary point of view, because you emphasize very specifically on this issue. So how to deal with this?
Very difficult. Because unless the human beings change, unless their culture changes, because it's a matter of our culture, which has become the part of our personality, that we like to misuse power and amass personal benefit out of that power. Unless that changes, and perhaps you know, it takes generation and generations before the character and the culture of the people changes. But as I told you, that democracy is the road where we have to walk constantly without reaching. So perhaps we should not expect that when a time will come when the country will be free of our corruption and misuse of power. It's a human process and therefore must continue unless the human beings change. And the people change, no doubt about it, no doubt about it. Because we say that the Western democracy are more mature. So they were not mature in the beginning. Because you know, when the Constitution was written, and in the Constitution they wrote, we the people. We the people did not include the women and the black people. Women were not given the voting right. It was that era. And now that era has changed, but still there are groups who do not believe in that, but time will come where the slow and silently the human nature and the character will change. But even then, now, at least there is a forum where we can challenge the misuse of administrative discretion and the resultant corruption out of it. So let us not feel worried about a problem. The problem will be there. We have to worry only our direction, that in which direction we are moving. If our direction is right, the problem will ultimately find solution. But when? Nobody can say after one generation and two generations. But I can say only this, that we are so far on the right path. And if we continue, ultimately we will be able to say that we have become a quality democracy, because impatience will not take us anywhere. We have to stay on the course, whatever it may come. There may be potholes in the road, there may be difficulties, anything, but there is no other road, only the road which has been demarcated in the Constitution by Dr. Ambedkar and Pandit Jawaharlal Nehru, who placed the objective resolution before the Parliament. The road is the only road. We should not deviate and should not worry when we will reach and how we will reach, because reaching is not important for us. Walking is important for us. Thank you, sir.
Thank you,
It was
sir.
a pleasure.
Thank you very much, sir. The way you have explained, analyzed, presented, and presented various aspects of the Constitution, processes involved, judiciary and its role played, and the most important statement that walking is more important than reaching, and if we are walking in the right direction, certainly we'll get a solution someday, sometime. So I have no words, but it's greatly enlightening, educating our students, our teachers. And sir, someday I request you to kindly visit Jaipur in person. We'll be very happy to welcome you. And in the beginning, I could not mention the name of Dr. Poonam Saxena. Yes, she's our friend. She's the Honorable Vice Chancellor of NLU Jodhpur, very kind. And your association with NLU Jodhpur makes it a big difference. So, sir, today's occasion has been immensely important for us and has benefited us in many ways with your gracious presence and very, very enlightening talk. With this, I would like to thank all those who have connected on today's occasion. And sir, with this, I once again express my gratitude for your kind gesture, kindness, and grace. And thanks to everyone. With this, we close the session, sir, with your kind permission. So say just one or two words at the end so that I'm able to close it, please.
Thank you very much, sir. Not only pleasure for me, for pleasure for you and university. It was a pleasure for me to meet and to discuss with a person of your eminence and qualification. Heard a lot about the university, and I'm sure the university under your guidance is bound to reach and make a mark so far as the education is concerned, legal education is concerned, and so far as the philosophy of Dr. Ambedkar is concerned. Thanks very much. It was, I think, pleasure for me.
Thank you, sir. Immensely grateful, sir. Thank you, sir. Have a good day, sir. Thank you.